Good morning, everyone. Can everyone hear me okay? Maybe just put in the chat, yes, if you can, just so I know sound's working fine. A warm welcome to you all as we head to a glorious sunny bank holiday weekend, hopefully. I'm Kath Harrison of JVP, and I'm joined by Alyssa Firstfield, Head of Employment Law at Scamlins and also Head Director at HR Anchor.
Good morning, everyone.
In a few minutes, Alyssa will update us on the latest developments and help us plan ahead with People Matters as we navigate our way to the hopefully short-term new normal. And I say short-term because we hope to get back to a real normal very soon. Now, before we jump to today's main topic, which is obviously very important, we appreciate that recruitment is not the key priority for all businesses right now, but I'd like to share some optimism as it's been an interesting couple of weeks for us here at JVP. I've certainly been picking up more of a positive vibe from employers that we work with across the UK and also from potential new clients too. We've seen an increase in inquiries from employers taking this quiet time to review their recruitment strategy, exploring how they can adopt new methods to attract great people, save time on the recruitment process and of course avoid the need to pay agency fees going forward. We heard from one Manchester-based employer yesterday, actually, who advised that the number of job applications they receive is significantly increasing, which is sadly to be expected in these difficult times, given that unemployment levels, of course, are rapidly rising. This particular employer doesn't have the resource or desire to wade through over 2,000 applications received for just one role, which is understandable. So their challenge led to an interest in our ATS and application screening service. And it's not the only employer that has recently been in contact with us seeking such time-saving support with advertised and managed applications. Another employer in contact with us this week is using the time to focus on their employee value proposition and employer brand. They're keen to make sure that they retain obviously great employees that they have, and that when they need to recruit in the future, that they'll be able to attract the best people from the crowds. So my tip for you all today is that if you've been doing right by your people as business leaders and HR practitioners, which I'm sure that you all have, then capture the insights on how your employees are engaged, supported and shown appreciation in these difficult times, and make sure that you're updating your social media channels and careers website with positive stories to showcase why your organisation is a great place to work. Here's a couple of examples that we just found on the internet recently, but I'm sure you've seen many if you've been on LinkedIn or Facebook of stories being shared of how people are being treated by employers. Even if you're not recruiting right now, it will leave a positive digital footprint that will be seen by potential employers in the future. So that's a quick insight to some of the positive exploring and planning ahead that we've started to see in the past week or two. We've also been really busy in the background here developing our new website, which will be unveiling very soon. And it will also coincide with the launch of both our new partner referral rewards program for HR consultants, because we get a lot of people refer to us through HR consultants, and also a new recruitment business partner retainer service for employers too. So drop us a line if you want to find out more. Throughout Alyssa's presentation this morning, you'll see you have the chat in the chat section and the option to post any questions that you may have, and we'll work through responding to as many as we can. I'll now hand you over to one of the most approachable, helpful and knowledgeable employment lawyers I know. Thanks, Alyssa.
Morning, everybody. Thanks very much for that intro, Kath. It's very kind of you. So as Kath said, my name's Alyssa Firstfield. I'm Head of Employment at Scamlins Law, and I'm also a director and one of the founding members of HR Anchor. What we're here to talk about today is planning the next steps for your business through this coronavirus crisis. So we're going to have a chat about the end of furlough, short-term working and redundancy, the COVID-19 testing regimes, and what the new normal might look like and returning to work. So looking at the next sort of positive steps that we'll be making. So we're going to crack straight on. We've got quite a lot to get through, so the pace might be quite quick. However, if you have got any questions, we will pick them up at the end. Where we've got some really sort of nitty-gritty legal detail as well, I'm going to be putting together some summary sheets that we can circulate. So if you're happy to be contacted and to be sent that information, particularly because we're going to be talking about collective redundancy as well, which can be quite complicated, rather than sort of bore you all to death, we will be sending out some good checklists and sort of step-by-step guides as well. So Straight on to what the end of furlough might look like. The scheme's currently scheduled to finish at the 30th of June. Now, there has been pressure for it to be extended. It has already been extended once. It was supposed to finish at the end of May, and it became very clear that wasn't going to be a sufficient period for this support to be in place. We also think that because employers were starting to then consult about redundancy with a view to people finishing at the end of May once that support stopped, that the government have put the scheme in place for an extra month to try and mitigate those job losses for an extra month. Whether that scheme's actually going to be extended, I'm not so sure. So far, it's cost the public purse about $8 billion. There's 6.3 million people who are being paid under the scheme. It's a phenomenal amount of people that are being financially supported by the government at the moment. And the Chancellor has already said that that isn't sustainable. The government has said, however, there isn't just going to be a cliff edge to the end of this furlough. They're not expecting it just to go to the 30th of June and then just drop off. They are looking at a measured way of eking out this scheme. However, we haven't really been given any indication of what that's going to look like, whether they'll cap the number of employees that an employer can keep on furlough, whether they'll be reducing the amount they're going to be contributing towards those employees, because at the moment the contribution is 80% or capped at 2,500. We're just not sure. All we've been told is that there won't be this cliff edge and it will end in a measured way. The talk is of wind down, not extension. So, you know, that may well change. Everything is extremely changeable with what's coming out at government at the moment. A lot sort of turning on the advice that they're being given as well. And we're being told is that it's when the time is right that they'll be putting that information out, which what we're taking to be at the moment is we just don't know. When thinking about what a practical end to furlough needs to look like, hopefully most of you have implemented furlough agreements. For those that we've represented, they've all been sending out furlough agreements when they're putting their staff onto furlough. And what we've included in those agreements is that once the government support stops, or if the employer decides that they need to bring an end to furlough for whatever reason, that may well be then to commence redundancy, put staff on short-term working, so that's reduced hours with reduced pay, return to normal positions or unpaid leave. So by having employees sign those agreements, we've got contractual agreement from the employees for any of those measures to essentially take place. Now, if you don't have a furlough agreement in place, if your staff have just agreed to go or sent you an email and said, yes, I'm happy to be on furlough, but you haven't got that nitty-gritty detail in there, once the scheme ends, if you don't bring your employees back, you may well be liable to pay them full pay even though they're not working. Otherwise, you face a breach of contract or constructive dismissal claims. Now, the exception to that is if your employment contracts contain layoff or short-time working clauses, you could then formally lay them off or put them on short-time working to try and mitigate that financial exposure to your business. So in terms of steps you need to be taking now, have a look at your furlough agreements if you've got them. There may well be a window now where if you haven't got those agreements in place, that you could put those agreements in place so that that return process becomes a little bit easier and gives you a little bit more flexibility. If you're not getting any agreement from your staff, because ultimately you can't force them to sign these agreements, if they're just not engaging and if you haven't got one in place, then all isn't lost. We can have a look at the contract of employment and see if you've got those contractual abilities to lay people off. Now, what we're saying to people is ultimately, as employers, you do have quite a lot of bargaining chips. If you have an employee who says, I'm already on furlough, I'm not signing a furlough agreement now, you haven't got a layoff clause, so you have to pay me full pay if you're not going to bring me back to work once furlough ends. Ultimately, if that's not sustainable for your business, you're going to have to be looking at things like redundancy procedures, which is the last thing employees are generally going to want. So whilst we're not suggesting that you threaten employees, it's not good for employee engagement, and particularly at a time like this when people are very worried, there's structured ways that you can have those discussions to say, look, we need you to be agreeing to these practical measures, because if not, then the business is going to have to start taking some dramatic steps once this support from the government ends. So we're 8 weeks into before the end of the furlough scheme at the moment. In terms of looking at how you can mitigate financial exposure for your business, what has become clear is that staff can serve their notice whilst they're on furlough, and you can put the 80% contribution towards that notice payment. So if you serve notice to a staff member to dismiss them, if you're going through a redundancy procedure at the moment, or perhaps someone's, within the first couple of years of their employment, if you serve them notice, they must get 100% of their pay. But during this furlough period, 80% of that will be contributed by the government under the furlough scheme. Timing is going to be very important to try and make the most out of this furlough scheme if you need to mitigate financial exposure for your business. So if, for example, a redundancy process can take 2 to 3 weeks, the furlough scheme could absorb 5 weeks potentially worth of notice for your staff. So by way of example, if you've got 10 staff to make redundant, they're all owed 6 weeks notice. So say they've all been with you 6 years. This is very simplistic just for the purposes of this. And they're all paid £300 a week. Without the furlough scheme, notice alone could cost the business £18,000. Using the furlough scheme, that could reduce the liability to the business to around £6,600. Whilst it can be used for notice, it can't be used to mitigate the redundancy payment. So if you're giving people notice to terminate, we can try and absorb as much as possible of that into this furlough scheme. However, the redundancy payment is still going to be the liability of the business. So this is a graphic that we've put together just to try and illustrate that point a bit better. So the example given here, we've got an employee who's served 10 years, so they're entitled to 10-week notice period. Along the bottom of the graph, you've got the number of weeks. So we've got a 12-week period. The furlough scheme ends at week 8, so that's 8 weeks away. If we started consultation now and it lasts the next couple of weeks and then notice is given, you've got that 10-week notice period then there to run. Now, as you can see, for the first 6 weeks, you're going to get 80% contribution from the government and you only have to make up that top 20%. But then for the final 4 weeks of the notice, that will be the business's liability. Now, if you waited to do your redundancy consultation until furlough ends at week 8, the business is going to have to absorb all of that notice rather than having some of it used in the furlough scheme. So hopefully that sort of illustrates the point a bit better. If you're not looking at something as dramatic as redundancy, if it's just that you need to manage the staff and the amount of staff that you've got in, and you may feel that you're a bit over-resourced, but it's only a temporary thing and you do feel things are going to pick up, then you can look at layoff and short-time working. So layoff is when no work is provided for the staff. If there's a contractual provision to state that you can lay your staff off without pay, it will generally be unpaid and subject to a statutory guarantee payment, which is £29 a week. If there is no contractual ability to lay off your staff, if you've got nothing that talks about it in your contract of employment or isn't even as a last resort in your employee handbook, then if you lay your staff off, you're going to have to pay them whilst they're not working. Unless your employee will agree to signing a new clause or a contract amendment to say that they agree not to be paid whilst they're off. They may well do that if they believe it can preserve their job in the long term, but you need to obviously apply some thought to the fairness of that process. If in reality you are going to be looking at making staff redundant, if you don't see a long-term position for this person because of the economy, perhaps we need to be looking at redundancy instead of layoff. What I would be saying is when you're planning these arrangements, if you're feeling like you're getting a bit lost in it all, make sure you take some advice on that. If layoffs last for 4 weeks in a row or 6 weeks in a 13-week period, so cumulative, employees can opt for a redundancy and they can actually trigger that redundancy process. So just be mindful, if you have got people who are laid off, you've got that you've started, you've got that contractual provision, you've got them on layoff and you're thinking, great, I've got a bit of breathing space, I don't have to pay them. That clock has started ticking and that employee could trigger a redundancy process if you leave them on layoff for too long. I just spotted a quick question from Pam. So can you start the consultation with employees whilst they're on furlough? Yes, you can. Obviously, the consultation is going to look a little bit different. If you are in the position where you can't have anyone on your premises because of COVID-19, if you haven't yet explored bringing people back, you need to be looking at virtual ways of holding that consultation. So sending out emails, making sure everyone is receiving emails and correspondence before you get started, and then have a look at software like Zoom and things like that to make sure that you can hold virtual consultation meetings. Now, there's various ways of doing these. I've got a client that we're supporting with this at the moment, and what they have is the main Zoom conversation where they include the employee and a trade union rep, and then there's a private conversation going on between the employee and the trade union rep as well, so that they can have representation with them, because they've got the contractual right with this business to have a trade union rep with them. So there's lots of ways that we can deal with rights with being accompanied and things like that, and actually making sure that someone has a fair crack at the whip with their consultation, so that we're not facing then procedurally unfair dismissal claims once this is all over. In terms of redundancy then, we talk about the magic 20 figure. So less than 20, it's a straightforward consultation, and you've got quite a lot of control over how you manage that and what you want to do. Now, if you make more than 20 people redundant in a 90-day period, you have to undergo what's called collective consultation. Employees have to be given the opportunity to elect representatives, and this often means dealing with trade unions if you've got recognition as well. You have to inform the Secretary of State. If you don't, there's large fines and potentially criminal sanctions. There's strict time limits for the process as well. So if you're making redundant between 20 and 99 employees, you need to have started the process at least 30 days before the first redundancy is made. And if it's more than 100 employees, that goes up to 45 days. Now, collective consultation is complicated, and you need to get it right, because if you are making that many employees redundant and you're going to be terminating that many contracts, with that comes an increased level of liability. If you get it wrong, even if it's only in say 25% of cases, and you just don't deal with those consultations quite right, that's still potentially a quarter of the people that you've made redundant who could be suing you for unfair dismissal, and mitigating all the financial measures that you've taken by reducing these jobs. So what we're going to do is send out a fact sheet after this webinar, so to give you some step-by-step guides just in case collective consultation is going to apply to you. What we are advising is you've got to be very careful with this. You get employers and they ring us and they say, well, we've got 5 or 6 people who, they're in their probationary period. We don't need them because our capacity for staff is reduced. If we terminate those, that brings us below the 20. Will that work? The answer is generally no. If you are cutting staff because of a reduction in need, so it's a redundancy situation, then once you're over that 20, you've got to consult, even if you've got people under the 2-year deadline. So for basic consultation, identify areas where you are overstaffed, where there's poor efficiency, and compile what you imagine your new world could look like. So if you don't have an existing structure map for your business, I'd suggest that you make one. So map out who works where, who answers to who, and set it all out in a chart so you can see what your business currently looks like. Identify where you're overstaffed, if your work is completely stopped in a particular department or completely stopped altogether for a certain group of employees, and then start making what you feel your new company the new normal can look like for you. So you have your old world in one chart, and then you create the new one, which is one where you feel you can financially support those employees. There's enough work to keep everybody busy. It might mean that you're amalgamating roles. It might mean that you're just reducing headcount. It could mean an entire restructure if you feel that the structure of your business currently isn't very efficient. It could mean an entire overhaul for your business. One thing I would say is definitely take advice when you're putting these new charts together, because it's one of those projects you can become very immersed in, and it all sort of makes sense to you, and then you get a third set of eyes to go, well, hang on, you haven't thought about this, what about this, who's going to do this, and just make sure that you really have looked at it from every which way angle. Once you've got your proposed new world, you need to inform staff of the difficulties that are facing the business. The reality is they're probably going to know that the business has been facing difficulties, particularly if they've already been placed on furlough, and explain why a restructure or redundancy is anticipated. You tend to find that you get a bit more engagement from people if they understand the actual process. If you just say, look, we're having a bit of trouble, we can't afford to support all of you anymore, we need to reduce headcount, that's not really going to get engagement. Whereas if you're saying, look, the future of the company, we don't feel that cold sales is going to work anymore, it's going to be more about business development and building relationships, those are the sorts of skills that we need, you're going to get more engagement on your consultation, and you're going to ensure as well that you're keeping more of the right staff. Just a quick question from Jan there. Do you have to follow the same process if it's less than 20 staff? So if it's less than 20 staff and it's not collective consultation, you still have to do a consultation, but it can be a slightly more stripped back. It's a little bit more simple. So you don't have to look at electing representatives. You don't have to inform Secretary of State, and there isn't a time limit on the process. So you've got a lot more control over that. So once you've informed staff of the difficulties that are facing the business, you need to inform those then who are at risk and advise them of the process that the company is going to undertake. So how many steps there's going to be to your consultation procedure, and how you're going to be looking at selecting staff. So at those consultation meetings, you have your meetings with the staff, you discuss any selection matrix, and if you're going to be interviewing, so say if you've got 5 people fighting for 2 jobs, you might decide to do a selection matrix and an interview to pull all your points together. So when we talk about selection matrix, you essentially put all of your employees into, or all the ones who are at risk anyway, into a pot together, and you look at allocating points to them, which sounds really brutal, but you're looking at disciplinary record, perhaps timekeeping, absences, performance and appraisals, and you score your employees, and that helps inform, you know, who it is who's ultimately going to be selected. Now, you need to be very careful with selection matrix, because you need to ensure that, say if you are looking at predominantly at absence and timekeeping, that if someone has a disability, if someone's been off and they're pregnant, that you're taking into account those issues. They are protected characteristics, and if you're not careful, you could end up with a discrimination claim on top, because someone with a disability could likely say, well, hang on, yes, you've applied the matrix to everybody and applied it to everybody equally, but because of my disability, I'm more likely to score poorly in the matrix that you have compiled. So you need to either ensure that people are given credit. So this might mean applying almost like a handicap to the figures, or looking at if you can pick selection criteria that are very neutral and aren't going to put those protected characteristics to any disadvantage, because you could potentially face an indirect discrimination claim. Now, that again is complex. If you need any advice on that, we are here to assist. So just let me know afterwards, either in the questions if you've got any particular concerns about that, or you can always drop us an email afterwards as well, and we can have a chat about it. So once you've concluded your consultation, consider any of the feedback that you've had from staff members. You could get a staff member who comes out with a blinding idea that actually changes things, changes your approach to things, or actually affects the number of people that you feel you need to make redundant, or the measures that you're taking. You then need to make your decision and issue the decisions and the notices. This is the really tough bit, particularly if you're looking at quite a few people and telling people that, you know, unfortunately, you're being made redundant, that their employment's going to end, and that they're going to be out on their own. The redundancy payments are made, and then you deal with any appeals afterwards. So I've got a question there from Catherine. If someone over 70 on furlough is asked to return to the business but can't due to government advice to remain isolated, can the organisation make them redundant? I'll touch on this as we go further on, but in terms of making them redundant simply because they won't return, it isn't necessarily a reduction in need. So the actual reason why they're not coming back is because, you know, they're shielding. Their job hasn't necessarily disappeared, so redundancy wouldn't necessarily be the best step with that. If you feel that they're being unreasonable, if they physically can return to work and they're not shielding anymore, you know, say if that measure comes to an end, then that's more of a disciplinary issue. You can include someone over 70 or someone who is shielding in a redundancy consultation. You don't have to treat them especially different, but don't confuse the different reasons for dismissal. If it's not that their job's no longer required, or they're not included in that headcount reduction, it's not really a redundancy situation for that person. Elaine, so if someone's, can you reach out to furloughed employees and suggest they carry out some non-work related online training as some employees aboard? Yes, you can. While someone's on furlough, they can do training. They can do training that's actually useful for their role as well. All I would say is if they're only getting the 80%, not 100% of their salary, if they're undertaking training for the business, you need to ensure that they're getting at least national minimum wage. If they're doing non-work related training, so say if, you know, they want to train to be a community first responder, or they're doing stuff to help the NHS, then yes, fine, they can crack on. You don't need to worry about pay for that. Contract changes. So say if you have done your redundancy or you don't want to make people redundant, but you can't maintain your current payroll. If you're all about, preserving these jobs and you think actually in 6 months, a year's time, I think we're going to be okay. We've got some really good key staff that we don't want to hang on, that we want to hang on to. We don't want to be sending them out into the job market and risk not being able to get them back. Consider asking staff to amend their contract to reduce their hours. Have a look at whether staff will agree to a reduced pay or hourly rate, and have a look to see if you can implement flexible working from home and reduce your overheads. So if you force a change through to reduce hours or reduce pay or reduce hourly rates, and that's potentially breach of contract, it's always better to consult with your staff, get their agreement to these sorts of things. In terms of the flexible working and the working from home, if someone's shown that they're really productive, so, say if you've got a staff base of 50, you've managed to have at least 30 of them working from home, they're productive, you're able to supervise them, things seem to be working very well, you can have a look at things like, do you need the size of premises that you've currently got? Do you need all the hardware and everything that you've got in your building? Do you need as much support staff? If you've been able to run your business effectively and people are making more use of digital aids and potentially even things like, so lots of solicitors firms are using like typing outsourcing and things like that. If those efficiencies mean that you can reduce your overheads rather than reducing the number of staff that you've got, then that's something that you can also look at as well. Don't forget about holiday pay liability. So whilst we've got all these measures and we might be looking at things like redundancy, how that we can make things more efficient, all the time employees have been on furlough, they are racking up holiday liability for your business. So say if you've got 100 people on furlough, they are going to have accrued a quarter's worth of holiday pay liability by the time they come back from furlough. And if you've got employees that are still working, if you've got people who are working from home, the chances are they're working very hard, they're helping to keep your business afloat. In terms of employee relations and employee engagement, if you then have everybody coming back from furlough and they instantly try and take a 2-week holiday, that's going to unsettle things within your staff. Those who've been working and those who've been working from home are likely to need a bit of a break when they come back. So make sure, check your contracts and make sure that you have a clause in there that states that if somebody wants to take a holiday, that it has to be approved. We'd also suggest that you contact all your staff and say, look, we are aware that you're accruing a holiday pay during this period. There is a process for you requesting holiday. If you book a holiday, if you pay for a holiday or try and go abroad and you haven't asked for permission to go, then there's a chance that either you won't be paid or there may well be disciplinary steps if you go anyway. So it's making sure as well that that liability is managed. What you don't want is all your staff coming back from furlough and you think, great, we're good to go, and then half of them take 2 weeks off. It's not going to be great if you've got a business plan for what's going to happen when people come back from furlough. So just make sure that you're conscious of that liability building up and that you've got a plan for it as well. The government have said that if people can't take annual leave whilst they're on furlough, it will be able to be carried over for 2 years. So it might be that you take the approach that you schedule all that holiday for your employees. Provided you give them notice, you can require them to take days on a certain day. So it might be that you ask your staff every other week that they have to take a day off and start to slowly drip feed that liability through rather than it hitting you all in one go. In terms of holiday whilst they're on furlough, if an employee requests it, you can approve it and they can have their holiday pay while they're off. They get 100% for that period and the government will contribute that 80%. The position still, unfortunately, isn't clear whether you as an employer can force an employee onto holiday whilst they're on furlough by providing them with notice of it. Now, the risk with this is if you say, actually, I'm going to risk it, I'm going to put my staff who are on furlough on holidays. If we then get clarification from the government to say that's not actually legal, that holiday hasn't technically been used, not only have you topped up their pay whilst on furlough to 100%, but you've also still got that liability to deal with. Now, if holiday is going to be a real issue and you want to get it dealt with, one way we are suggesting it can be dealt with is to call people back off furlough, put them on holiday, they take their holidays, use them up, and then they go back on furlough. The problem with that is whilst they're off furlough and on holiday, you're liable for 100% of the holiday pay. So it's a bit of a sticky one to navigate this. My suggestion to businesses is try and eke out that liability over the 2 years and really schedule when people take it. That is going to require quite a lot of hands-on involvement from your managers and potentially HR. to make sure that that goes smoothly and that everybody uses up their entitlements. But communicate with your staff about it, make them aware, look, this is an issue for the business, it's going to be a big expense, this is how we intend to deal with it, so that as well you don't have those employee relations issues with people coming back from furlough and taking themselves off on holiday for a couple of weeks. So a quick question there from Alison. What approach should you take if all but a couple of staff agree to a salary reduction? So with that, if it's only a temporary measure, you could potentially say to the staff, well, look, we are forcing this measure through. If they refuse, you give them notice to terminate their contract and you offer them a new contract on the reduced salary, making it clear in that contract it's for a temporary period. So that then if those couple of staff then did try and claim constructive dismissal, you can show that you've tried to get agreement, you've given your business reasons why. Yes, it's still technically a breach of contract, but by offering them the new contract on the terms that have been agreed by other staff members, that you've got an argument about of mitigation then as well, which can be quite useful if you needed it for tribunal. Christine says, is it only furloughed staff who can defer holiday for 2 years? So what government has said is if people have been unable to use annual leave because of coronavirus, that they can carry over that annual leave 2 years. So I'm going to give you my own example. So since this matter has all started, I was actually talking to Kath about this before, I haven't been able to take a day off. I'm absolutely exhausted, working all hours as most employment lawyers and HR people are. So technically for me, if my job carried on at this sort of pace through the rest of this year and I've simply been unable to take any annual leave, then there's an argument that I will be able to carry that over for the 2 years. Catherine, is it only staff that are on furlough who can have their holiday entitlement used up? So I think that's sort of the same question as what Christine said. Again, it seems to be anyone who's affected by coronavirus who's unable to use annual leave. That doesn't mean if you've been unable to go abroad, that doesn't count. It's annual leave is just a right to time off. So if because of the situation with coronavirus, an employee hasn't been able to use annual leave, they are able to take that entitlement over the next 2 years. Lana, can an employee on furlough take paid work for another employer? Yes, they can. But what you should be checking as well is whether you have a restriction in your contracts that say that they can't work for another employer, particularly if it might create a conflict of interest or something like that. But the government has said that if your staff are on furlough, that the furlough scheme doesn't prevent them from taking other employment. The only thing that would stop them doing that is if your contract of employment says that they can't. So moving on to testing. So it's a very swift changing topic, this one. It depends at the moment, very frustratingly, on whether you're in England or Wales. Wales is now starting to catch up. We were about a week behind where England were in terms of what their testing regime was going to be. Really important point we're making here, before we even move on to who can get testing, that testing is not the final solution. You could have a staff member who tests negative, comes into work and you think, brilliant, I know this person hasn't got it. They could pick it up on their way home in Tesco's, they could get it from the kids. So one test for every staff member isn't going to make a safe working environment. This is a very fluid situation, and you need to be aware of the fact that just because you might have one test result on file for every staff member, that doesn't mean that you're going to be coronavirus free in your workplace. Now, this graphic, I think it's coming out a bit small on here, so I can send this out after the webinar if you want, and it actually needs updating because it changed again yesterday. But essentially, this is who can get tested at the moment. So if you're in England, if you are a care staff worker or you work in the NHS, then you can get tested. So if you're running a care home, if you've got a private ambulance service that you are, if you're lending your facilities or outsourcing to the NHS, or anything like that, the chances are that you will be able to get your staff tested. There is a portal online where you can register. We can send out that link as well. So you register then to get your staff tested. So there's a new list, very confusingly, of essential workers. So we had essential and key workers for who can and who can't work, and that was a few weeks ago. It seems like forever ago now. And now there's a new list of, in Wales, I think they're calling them critical or crucial workers, and then in England, it's essential or key workers again. So on that list, it's a bit more restricted than the initial essential workers list. So we're looking at, like, for example, take the legal system. Technically, solicitors are classed as key workers. Under this list at the moment, it's just judicial staff, people who needed to keep courts running, and people who need to be operating for things like child arrangements and stuff like that. So if you're on that list, then and you have symptoms, you can get tested. If you don't have symptoms, then again, at the moment it's just people who are symptomatic. If you're over the age of 70, again, with symptoms, you can get tested. In Wales, it was just if you are NHS or a critical worker and had symptoms, whereas now people who are asymptomatic, who are working in NHS and the care system can get tested. And I believe that they will be updating then as well, so in line with the shielding and vulnerable people as well. Now, this is, like I'm saying, it's not even changing by the day, this is changing by the hour. So as the capacity to take on more and more testing is increasing, they are rolling this out, so it's wider and wider and wider. We are expecting within the next couple of weeks that employers who once the measures have been relaxed, which we think is also coming, and more businesses and more people can get back to work, that you will have that ability to test your employees. Now, there are issues with testing. It isn't, like I say, it's not sort of the golden solution to everything. If your employees have given you consent to undergo medical assessment, and that might be in a sickness clause, that doesn't necessarily mean that you have consent to medically test your employees. This is a very different kind of consent, and this is more like medical screening. So if you're the kind of employer who does need to medically screen your employees before they start with you, you may well have this consent, but if not, you need consent to test your employees. Release of results. So just because you're able to test your employees doesn't necessarily mean they have to release the results to you. So again, you need to make sure you've got that consent in place, and it does need to be free consent. Once you've got test results, there's obviously confidentiality obligations, and the results will be classed as special categories of personal data under GDPR. So you need to ensure that you're treating those very carefully, that you've got security with how you're keeping those results. If they're electronic, make sure that you've got sufficient security measures in place. I wouldn't advise keeping paper results in the office under the current GDPR regulations. It's just probably not going to stack up with what your obligations in that respect are. Just touching on confidentiality a bit more. Because coronavirus is so freely spoken about, it's such a hot topic, it seems to be all anyone's talking about, and you can guarantee once people are back in their offices, they're going to be talking about what their experiences with coronavirus have been, what their furlough was like. Everyone's going to be discussing it. Just because it's free conversation in the office does not mean that if someone tests positive for coronavirus, that you can tell other employees, Joe Bloggs, who sits down the corridor, he's tested positive, we've had to send him home. It's still confidential. So again, if you have an employee who tests positive and they're in the workplace, is making sure that you're dealing with that properly and that you're not subverting the employee's rights to confidentiality simply because we're in the middle of a pandemic. So again, there's quite a few steps that we can advise with that, but ultimately the best option is simply to say nothing. If somebody asks why somebody's not in, it's ultimately, if you're saying, oh, it's confidential, can't talk about it, that can almost lead someone to think, oh, well, it's a medical issue. Ultimately, if people are being told the workplace is safe, if you've done your risk assessments, if someone's not in, it isn't really anybody else's business. But we'll be coming on to difficulties with employees specifically further on in the presentation. Once you're bringing people back from furlough, we would suggest trying to deal with that consent there and then. So even if you haven't actually got the intention to test straight away, if you don't necessarily think it's necessary, as this situation unfolds, like the advice on face masks and gloves seems to be changing. From one week, people are saying that face masks should be in place, and the next week they're saying that they shouldn't. The same thing is likely to happen with testing as to how useful that's going to be in the workplace. So my suggestion would be get those consents on file when people come back, so that then if your position in the business changes and you decide actually we do want to do a testing regime, that you've got those consents on file. They need to be very carefully worded. They can't just be, I agree to medical testing for coronavirus. We need to deal with things like releasing results, confidentiality, potentially even release of medical records, because if you've got someone who's vulnerable, underlying conditions and things like that, you need to know how to manage that person going forward. So do take advice on those on those forms. So getting back to work, what the new normal could look like. There's been lots in the press about this this week. There's a lot of public pressure for the current measures to be relaxed, and it does look as though the murmurs that we're hearing coming out of government around roadmaps and what the new normal could look like, it does look as though that's coming. So Scotland set out what their roadmap was yesterday evening, but Nicola Sturgeon has made it clear this is what we're looking at, but it's not coming into play yet. They're still keeping those lockdown measures in place for some time yet. So in terms of actually bringing people back to work, risk assessment, you need to review your workplace. You need to have a look at where people congregate, where they eat, where they drink, where they share facilities, and have a look at what the risks are. We've got a great template as well that we can send. So after this session, if you want to have that template, you can work with it, change it, make it applicable to your workplace. We're happy to send that out as well. You need to consider, do all staff come back at once? Do you need to implement shifts? You might be a business that's never, 9 to 5 in the office where you've never dreamed of having shifts. Again, you'd need staff agreement for that. But if it's the case that you've got employees who are all sitting around shared desks or several people to an office, if you can't comply with social distancing and it's not safe anymore, you need to consider then either, if you can't move people around, if you simply haven't got the space, whether you have people in on shifts. So you might have some people working in the morning, some people working in the afternoon. Can you rotate them on and off from working from home? Or is it going to be a case of hours reduction or changing your working hours so you can have people in and do a very early slot up to lunchtime and then a slot from lunchtime to late evening, and see if you can move things around. So do all functions need to be completed on your premises? Can you have people working from home? It's likely the government is still going to stick to that. If you can work from home, you should. So simply because you want them back in, if they can be effective from home, you still need to give consideration to that and then consider rotating people on and off. I had a meeting with my fellow directors this morning, and, we'll agree that the workplace for so many businesses is going to change. People are going to become more efficient. People are going to be looking at the functions they actually need, but also having a look at, do we need to modernize a bit? Do we need to have people who can work from home working flexibly in terms of their hours and support functions and then things like that? So, the measures that you take now could well set out the roadmap for the way your business works and operates and looks in the future for years to come. So it's important to get it right. It's important to, apply a lot of thought and take advice on it now as well. In terms of government suggestions, so things that they have suggested, floor stickers. You've had health and safety companies come out straight away producing their own. So there's lots of packs out there that are there to be purchased. So you might have these around printers, you might have them around water coolers so that people have to stay a certain distance apart and a certain way that you move around your office, particularly if you're open plan. If you can put screens up, so for example in our office where you've got solicitors who supervise trainees and paralegals, often we share a room, so they're on the other side of a desk, so that obviously it's great for a learning capacity, but probably not so great for social distancing. So if that 2-meter rule isn't relaxed or it's not relaxed enough, whether actually office sharing can continue or whether you need to implement screens. Limiting use of communal photocopiers. Do you really still need to be using photocopiers? Can you look at paperless solutions? If not, if you're very much still paper-based and you need to be for your sector and your industry, then making sure that you haven't got people congregating around photocopiers, and making sure that you have got one-way systems and things like that and stickers down so that people know how far to stand away. You might need to look at closing canteens if you've got communal staff areas, implementing rules about sharing facilities, so particularly toilets. If you haven't got lots of toilet facilities, whether you have some sort of system for being aware whether somebody is actually using facilities, whether it's only one in, say if you've got 4 or 5 cubicles, whether you take the decision actually only one in the entire bathroom at once, things like that. Personal stationery, so no sharing pens, no swapping staplers, hole punches, that sort of thing. They've all got to have their own stuff, and potentially not sitting opposite one another. So question in from Laura, what are the company responsibilities in terms of kit and equipment when working for a longer period from home? So if someone is working for you from home, this is a really good question, you do need to ensure that they have got the proper equipment to be able to do their job. So if you would ordinarily provide them with a desktop and they're actually using their own personal laptop, one, from a GDPR perspective, you need to consider whether that's actually appropriate because you haven't got any control over that machine and potentially your customer information and data. So it might well mean investing in new hardware, new software, having a look at VPN access, security arrangements, and things like that. Now, if somebody says, I need this really fancy pants printer, I need this, that, and the other, just because they've requested something, you don't have to give it to them. It only needs to be what's reasonable for them to be able to do their job with the demands that you place on them. Now, one thing that we are seeing quite a lot of is desktop assessments. So when you've got people who are working in an office, good practice is that you should assess how they're sitting. Is the computer screen at the right level? Can they access everything? Is their back straight? Are they liable to get a sore neck or something like that? Obviously, if they're at home, that becomes a little bit more difficult because you can't actually go out and assess them. So looking at guidance for employees about sitting on a proper chair, making sure that their computer's at the right height. If they haven't got the ability to prop something up, have a look at things like desktop stands and things like that. So it might well be that you survey your staff that are working from home and make sure that they, have got everything they need. And it could be that you ask them very open questions and say, look, ideal Christmas list, what would you want if you're working from home? We're not saying we're going to give this to you, but they may well be aware of equipment that is useful, that you can actually see a business case for, that's well worth purchasing. Now, remember, that stuff does belong to the business. So if they were to leave, that equipment's got to come back, and make sure whatever you're sending out, that you're keeping a schedule of what everybody's got. So if everybody leaves, you've got a list of things that you're expecting back as well. If you are going to review contracts of employment and things like that, and there is more equipment going out, it's a good opportunity to put a clause in about if somebody damages something or fails to return something, that you've got the ability to withhold money from their final pay as well. So just in terms of like a quick list of, say, for example, what I've got working from home. So I have a headset. I've got a desktop stand, so it goes on my desk and my computer's on that, so it's raised, which was as a result of a lesson that I hope never to repeat, which just went on to a Zoom call, wasn't quite ready. I was leaning over my computer and gave everybody a shot up my nose on the video camera. So now I'm at a height where I can look straight at the camera. I do have a ring light as well for things like this, so lighting's a bit better, and ensure that I have a blank wall. And I also have wireless keyboard and mouse as well, so that I'm not hunched over. I've not got cables everywhere. I can sit up straight as well. So it's very basic. Oh, I've got a laser printer as well. So very basic. I don't need loads of stuff. I'm very much just computer based in the job that I do. But just little tweaks can make the job a little bit better and also make things look a bit more professional as well. So getting back to work, there's the compulsory tracing. Well, whether the tracing app is going to become compulsory or not, we're not actually aware yet. So whether you are going to require your employees to download that app, so that then that you're aware within the workplace, obviously if someone comes to you and says it's saying I've come into contact with someone with coronavirus, whether that is going to flag to you whether there's an issue in your workplace. Plan measures in the event that someone is symptomatic or falls ill at work. If someone falls ill, is there somewhere where you can isolate them whilst measures are taken or steps taken to ensure that they can go home? Ways of reviewing who's come into contact with who. So if people, you might have your stickers out and people are moving around the office, but actually, should you be telling people, limit your contact as much as possible, because if you become ill, we're going to expect a list from you of the people that you've come into contact with. And just remembering that point I made earlier, that confidentiality still applies. Think about your measures with clients and customers. Is it going to be acceptable to have people coming into your premises, or do you still need to be doing things by video? What sort of steps are you going to be taking for when people come in to ensure that they are safe? On that safety point, one question that we get asked quite a lot is if an employee falls ill, or say someone, God forbid, somebody died or had a long-lasting disability as a result of coronavirus, would they be able to bring a personal injury claim against your business? Now, I'm not a personal injury solicitor. I do have a colleague who I've put this question to, and she was saying that the issue with this is the matter of proof. You have to prove essentially that someone has contracted the virus in your workplace. So if they were coming into work, you've got lots of lovely safety measures in place, but actually they've been going around to their neighbours at night and having a couple of beers. Can they prove that they haven't got it from the neighbour and not got it in the workplace? So there's quite a lot of hurdles for employees to get over. However, the message that comes out of it, I would say, is try and ensure where possible that your workplace is the gold standard. Because if you've got employees who are frightened and threatening to stay away from work, which is something that we'll come on to, you're going to, it sort of increases your armoury in terms of what you can say to the employees and what measures you can take if you can show that you've done your risk assessments and that the workplace is actually safe. So back to measures. We've already talked about approval for holidays, but are you going to continue with potentially a blanket ban on travel unless absolutely essential? Scheduling annual leave, which we've discussed, and compulsory vaccinations. This is going to be such a hot topic. I don't know if you're aware of the anti-vaxxers. There's a huge movement in the States where you've got people who are very anti-vaccination, refuse to have their children vaccinated. I do believe there are some countries in the world where if you want to access public health and public education, it's compulsory to have your children vaccinated, and some businesses in America have taken that step as well. Now, it was all a very interesting discussion when, prior to this pandemic. However, now where you're looking at, if a vaccination were to become viable, and it becomes something that becomes common, whether you can take the step to state that it's compulsory for your staff members to have that vaccination, whether that is a step that legally employers are going to be able to take. This is something we're going to be looking at a lot more closely. We're going to be issuing lots of guidance about it if the vaccination does come out. It looks like that's going to be later on in the year. And in terms of people's human rights and things like that, whether that is something that you can enforce. But I would say, keep an eye on the press, because particularly with the anti-vaxxer movement, this is going to be something that's going to become a very hot topic the minute that vaccination gets released. The second wave, this is being talked about again in the press more and more. So ensure that, if you get to the point where you're able to bring staff back, your operations are going again, and you feel like you've found the new normal, what you don't want is that second wave to sort of knock you off kilter again. Try and make sure where possible that your business is insulated, that you've got steps that if a second wave hits, potentially without government support, if that public purse isn't going to allow it, that you've got a plan, a business plan and a route out to try and keep your business afloat. So what if staff won't come back? So there is a lot of fear out there. What we're seeing a lot is people sort of saying that this coronavirus is making people very insular. They're frightened of leaving their homes. And apparently where you see these surveys go out and about where people are saying, do you want lockdown to be lifted? There's a vast proportion of people, those who are at home particularly, who don't want those restrictions to be lifted. And then you've got businesses who are obviously saying, no, we absolutely want them to be lifted. We need to get our businesses up and running. The economy is getting smashed to pieces. So whilst there's that balancing act, underneath all of that, you've got this underlying fear that's building, where you've got people who are becoming so frightened that they do not want to leave their homes, full stop. Not necessarily just go to work. They don't want to go out. They don't want to see people. They don't want to go to the shops. They literally want to stay at home because they're so terrified either of catching the virus or giving it to their families. So once you've got your workplace in a situation where you feel it's safe for them to be able to come back, you've taken all the necessary steps, you're not on the prohibited list, so you're not, a restaurant or a bar and in the position where you simply can't open. You feel that you can open safely and resume trading for some sort of operations, and you've got people who just will not come back. What we're saying is discuss, reassure, then warn. Don't go in heavy-handed straight away with, if you don't come back, then you're going to be dismissed. So discuss their concerns with them, see how serious their concerns are, because what we're also saying is staff's mental health is going to have been seriously affected through this as well. So discuss those concerns. Do they need a referral to occupational health? Do you need to tell them to go see their GP? If you think they're being, just a bit awkward, they're enjoying staying at home, they're being paid, they're on furlough, it's a case, perhaps we can take a bit of a firmer line, but have that discussion first and see where the worry is coming from. It could well just be, my cousin Janet told me if I catch it because I, had a bad cough when I was 7, I'm going to die. There's a lot of false information out on Facebook and Google, and even in some of the media as well. So get to the bottom of those concerns. Reassure them then. So go through, look, these are the steps we're taking in the workplace. We've already had potentially some skeleton staff back. There's no indication of symptoms. Everybody seems to be fine. It's working. And explain to them the steps that you have taken and the risk assessment that you have gone through and how you're going to address those concerns. If they're still refusing to come back, then warn them and say, look, we've taken these steps, we've listened to your concerns, we are supporting you. However, you have a contract of employment with us. We consider the workplace to be safe. If you still refuse to come back, then we may have to take formal measures in respect of your employment, and that could potentially be dismissal. So all the while, as I've said, considering staff mental health, have a look, potentially even phased returns. People have been home for a long time. So if, I don't imagine this is going to happen on Friday, but if on Friday Boris Johnson says, we're going to relax social measures, you can all get back to work. If you then say to your employees Saturday morning, we're all expecting you all in full time on Monday, that's probably not going to be the best measure to take. It's very sudden, it's a very quick change, and you're going to be missing out all those steps in terms of discuss, reassure and warn. So make sure that you are taking a reasonable approach to this, and consider, whilst yes, your business needs to be operating, you need your staff in, but engaged staff and staff who want to be in are going to be more productive for you. So make sure that you take those supportive measures when they're coming back. Consider things like peer support. If someone's coming into the office, they're in full time and they've been home with their kids for 6 weeks, perhaps they're going to need someone they can have a bit of a chat with at work if they need to, and the ability to offload. And if people are struggling, you've got all that accrued holiday that you can use to help them reduce their working week if they need to, potentially as well as part of the phased return. So you can use up some of that liability as part of that phased return. Ultimately, though, if you have assessed the workplace, you've taken measures to make it safe and approached it reasonably, they must return to work when do so. However, we think this is going to be rife with issues about health and safety in the workplace and protected disclosures. So if someone makes a protected disclosure because they think the workplace isn't safe, they're refusing to work because they think that the workplace isn't safe, then and you put them to a detriment because of it, if they've got if they firmly believe that there is an issue and you've treated them badly because of it, you could be looking at a protected disclosure claim or whistleblowing claim. Again, it's a very complicated area. If there's even a hint of that sort of an issue, just give us a shout, and we can have a look at that for you and help you with it. It might be something that we look to maybe do a session on further down the line, potentially on the vaccination issue, testing in even more detail once the full testing regime has been rolled out, and then that specific health and safety and protected disclosure, because that's where the real liability is probably going to be in terms of the future going forward. Because whilst they're saying that this could be something that we have to deal with for months, even years to come, that health and safety and protected disclosure and whistleblowing issue is going to continue as long as this virus is around. So whilst you might get to grips with redundancy, get your workplace sorted in that respect, that's going to be an issue that's going to continue for some time. So just before I move on to the final points, Gemma says, if someone has a holiday abroad for September and they decide to go, can we enforce 2 weeks stay-at-home quarantine when they return? In terms of holidays, what we're hearing is actually people, whilst airlines might be getting going again, I think Wizz Air started again this week, that really it's not going to be that safe to go away. What my suggestion would be is that you say to employees that we are not endorsing you going abroad whilst there are still measures in place in the UK. If you still decide to go abroad, that if you come in home and have to isolate, that you're going to be on SSP or potentially unpaid if we've warned you not to go and you go anyway. That's quite a strong step to take. So again, before issuing any correspondence like that, do take advice. However, September is suddenly starting to feel very close. And if people are going to be going abroad, you haven't really got any control over where they go. There's still countries that are very much struggling with this. They're now talking about a second wave in China, that Germany might be bringing in a second lockdown. That if people are still planning on going away, fine, they can use their holiday entitlement. However, if they come back and they can't come into work, that you're not necessarily just going to be paying them to sit at home for another 2-week isolation period. So Dawn, does an employee have to notify the employer if they've taken paid work for another employer whilst on furlough, provided their contract allows? And do the employees have to be available for welfare calls or business update whilst on furlough? What's the reasonable time frame for employees to return a welfare call message? Okay, so really good question, Dawn. They don't necessarily have to inform their employer. We don't really deal with many employee inquiries and work. However, where they've asked us this question, we're saying is tell your employer. It's always better to be open about it. So from an employer perspective, it might be worth sending out a correspondence to say, look, obviously if your contract allows it, you are able to take paid work. However, your contract of employment is with us. If we need to recall you off furlough, you need to be able to come in when we say that you're coming in. If you shouldn't be giving priority to this other job. In terms of welfare calls and business updates, if it's going several days and you're not hearing from them, then that's obviously going to be an issue. But again, I would set out your expectations to them. So if you say to them, if we call you in the morning, we expect to hear back from you within 24 hours, or, if it's before 10 o'clock in the morning that they get something that it's the same business day, I suspect that will be What I would say is before you start saying, well, that's not acceptable, make sure that you've told them where the boundaries are and what you want. So if you haven't already done an update to people who are on furlough and you haven't really been in touch with them, like a newsletter or a general email or something like that is a good way of making sure that all this information goes out as well, and making sure that you have a means of contacting people as well, because if they haven't got company laptops or things like that, making sure you can actually still get in touch with people. So hopefully that's answered all of that. So final points, the next few months are going to be fraught with issues. There's lots to consider and manage. Please don't hesitate to take advice, and particularly when people say they can't afford to take advice or the business can't absorb that cost, just consider the cost and the benefit of doing that. So if it all goes wrong, your liability for each employee could be upwards of 10, 20,000 if someone's triggered redundancy, if there's a protected disclosure complaint, if you haven't served the notice properly, or if you treat a reluctant returner incorrectly. Whereas if you take advice, lots of firms are actually doing free advice, not just limited to us. So if there's someone local to you, or if there's a firm that you want to support, that's brilliant. And lots are also offering retainers spread over several months, which is what we're doing as well. And we're also offering 3-month support to anyone who is affected by coronavirus with HR outsourcing and legal support, which doesn't require insurance. So, if you have any problems, please make sure you take advice. And like I say, this isn't a sales pitch, not necessarily from us. If you've got a solicitor, please call them, because if you're taking advice from your accountant or something like that because they're throwing it in for free, you could just be making a problem significantly worse and introducing a financial liability that wasn't there to start with. So if anyone has any questions, please put them up on the chat. I think we've managed to get through quite a lot of them, and Kath's popped back up now as well.
That's fantastic. Thanks so much there, Alyssa. So much useful information. Just one more before, I know Claire had mentioned this one earlier, actually, we just missed this one. Collective consultation for redundancy, more than 20 in the whole company or in an establishment, etc.
So this is actually quite a complicated distinction. So if Claire doesn't mind, actually, I'm quite happy to send some more detailed guidance to you on that. But what we suggest as the starting point is if you have got several sites and you're making 2 or 3 redundant from each, initially when you're looking at this from a risk perspective, consider that is all as if it's all one site, and then look at the distinction between establishment sites and things like that, and whether you can get round that 20 employee limit that way. Like I say, I could probably talk for half an hour on that, and I don't want to bore everybody to death. But Claire, if that's a specific issue for you, drop me a line and we can have a chat about it, and I can put it in the guidance as well.
Great. Well, I hope that's all been as useful for you all as it has been for me. Very insightful. And thank you so much, Alyssa, because we can tell by the way your phone is vibrating an awful lot that you're a very busy person. And we really do appreciate the support and advice that you've given today. So thank you all. No doubt we'll be back very soon with more webinars to keep you all up to date. And any questions that haven't been covered, send them our way and we'll do our very best to help, as Alyssa said. Thanks so much. Take care. Keep safe. Bye all. Bye.